On 20th April 2024, Department of Legal Affairs, Ministry of Law and Justice, Government of India organized a conference on India's progressive path in the administration of criminal justice system. The inaugural session was held in the august presence of Honorable Minister of State, Ministry of Law and Justice, Shri Arjun Ram Meghwal. Honorable Chief Justice of India, Dr. D.Y. Chandrachud, was the chief guest of the session. Attorney General of India Shri R. Venkatramani and Solicitor General of India Shri Tushar Mehta also graced the occasion. The theme of the conference was introduced by the Additional Secretary, Department of Legal Affairs, Dr. Anju Rathi Rana.
Today we embark on a journey of enlightenment and exploration, delving into the heart of one of India's most crucial endeavors, the transformation of its criminal justice system. India's legal landscape has witnessed transformative changes. The enactment of the 3 new criminal laws, the Bharatiya Nyaya Sanhita 2023, replacing the Indian Penal Code 1860, Bharatiya Nagrik Suraksha Sanhita 2023, replacing the Code of Criminal Procedure 1973, and Bharatiya Sakshi Adhiniyam 2023, replacing the Indian Evidence Act 1872, heralds a new dawn in our quest for justice. These legislative milestones are set to replace outdated colonial laws, symbolize our unwavering commitment to adapt and evolve with the ever-changing dynamics of our society. Enacted in December 2023, these new laws are poised to reshape the criminal justice system, set to take effect from July 1, 2024. These reforms reflect India's commitment to modernizing its legal framework, enhancing efficiency, and ensuring justice to all. Today, as we gather to unravel the intricacies of these legislative reforms, let us remind ourselves of the core objectives that underpin our efforts. Our aim is not merely to enact laws, but to ensure their effective implementation. Our goal is not simply to punish the wrongdoing, but to prevent it. Our mission is not only to uphold the rule of law, but to safeguard the rights and dignity of every individual. In the pursuit of these ideals, we are guided by the wisdom of our esteemed legal luminaries, the dedication of our law enforcement agencies, and the resilience of our judiciary. Together, we stand poised to sculpt a future where justice is not a distant ideal, but a tangible reality, where the scales of justice are not tipped by bias or prejudice, but by fairness and equality. Let us embrace the spirit of collaboration, innovation, and empathy. Let us pledge to work hand in hand, shoulder to shoulder, towards the realization of a shared vision, a vision of a more just, more compassionate, and a more progressive India.
Secretary, Department of Legal Affairs, Dr. Rajiv Mani highlighted the importance of the new criminal justice system.
As far as the reformation in the criminal laws administration justice system is concerned in the country, we had a rich ancient legal system, which, of course, the Shruti and the Smritis were the primary sources of law. Over a period of time, when the Mughals came, the law was based on religious practices of the ruling powers. But with the advent of the Britishers in India and the colonization of the country, the new system of codified law had come into being. And what I would like to emphasize here is the fact that the codification of the laws done by the Britishers was in fact for their own benefit. As it is pertinent to recall that Dadabhai Naoroji, in his book Poverty and Un-British Rule in India, which was published in 1901, he emphasized the fact that the British policies were just formulated to see that the wealth of India could be extracted to finance British industries. And that led to, to the great detriment of the Indians and, of course, the downfall of the local industry and other things. So you can imagine the rule of law in the manner in which was established by the Britishers to serve their own needs. The Britishers codified the law in terms of rationalization in the Weberian sense to ensure order, certainty, and uniformity. However, the elements of colonial rule applied by Britain to its former colonies included control over land, divide and rule, apartheid laws, and just heaping discrimination on the native population. In fact, the original Code of Criminal Procedure of 1862 separated jurisdiction of the judges along the racial lines. The Indian Press Act, the Prevention of Seditious Meetings Act, the Rowlatt Act, and the Public Safety Bill were all, in fact, formulated to help the British tighten their grip over India and put the Indian freedom fighters in prison and to the distress of the native population. These laws, in fact, gave vast powers that helped British perpetuate the structural violence against the native population. Though the British codification was to justify what the British would say that it is a guarantee of rule of law and justice, yet in reality, these laws were used to discriminate between Indians and Europeans. We cannot forget that the existing criminal laws define the state-citizen relationship based on the colonial prejudices and practices. The British had introduced the criminal codes in the aftermath of the 1857 War of Independence to exercise their authority over Indians whom they condemned as an inferior race. In fact, the same theory also perpetuated in some other laws after independence. The Janavishwas Act 2023, which has been enacted last year, has in fact decriminalized 183 provisions of 42 central acts administered by 19 ministries and departments. The whole idea is to limit the curbs on the people and the businesses and to reduce compliance in order to achieve the goal of Viksit Bharat. The key forces which in fact are guiding the legislative department also in this process is the simplification of the procedure, the simplification of laws related to applications, etc., etc. Rationalization of the legal provisions by repealing, amending and omitting of redundant laws. In fact, since the last 10 years, 1562 laws have been repealed by the parliament. So the whole ecosystem is actually to promote the Indian mindset and to get away from the colonial mindset which was evolved and established to serve the colonial masters. India has a rich heritage. We can draw from our ancient heritage and legacy to administer the country in the right manner, in the manner in which our ancestors had devised for the next many, many years. Dhanyavad, Jai Hind.
Secretary, Department of Justice, Shri S.K.G. Rahate, in his address said,
As we all know, Ministry of Home Affairs, Government of India, after a very comprehensive review of the colonial era criminal laws, that is IPC, CRPC, Evidence Act, and after extensive consultation with all stakeholders and legal experts, has drafted the new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksha Adhiniyam. In fact, the enactment of these laws acknowledges the fact that the evolving nature of crime in the present times, particularly the cyber and advanced economic crimes as well as other heinous body crimes, require the law to adapt to these modern challenges, and thus a long overdue overhauling of criminal laws was undertaken and successfully completed by MHA. In the context of this latest criminal laws, what would be the role of Department of Justice is what I would like to share with you today. The mandate of Department of Justice is to facilitate the administration of justice. In order to make the justice delivery system more efficient, more accessible, more transparent, and with a citizen-centric focus, the Department of Justice is taking several initiatives. One such is the implementation of the e-courts project for the computerization and ICT enablement of district courts in close association and guidance of E-Committee of Supreme Court of India. Phase 3 e-courts project is envisaged as the next higher digital and IT empowerment of Indian court system. It aims to usher in a regime of end-to-end digital, online and paperless courts through digitization of the entire court records, including legacy records, and through universalization of e-filing and e-payments by saturating all court complexes with one-stop shop free of cost for e-services for the common citizens in the form of Seva Kendras. It will put in place intelligent smart systems enabling data-based decision-making for judges and registries while scheduling and prioritizing cases. It will create a unified technology platform for the judiciary which will provide a seamless and paperless interface between the courts, the litigants, and other stakeholders. E-Court Phase 3 includes several components employing latest emerging technologies like machine learning, blockchain, artificial intelligence that will change the entire landscape of the Indian courts. The 3 new criminal laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksha Adhiniyam, incorporates several electronic features now in the crime investigation and trial, like issue of summons in electronic form by the courts, production of electronic communication as evidence, videography of search and seizure, lodging complaints through e-FIRs, definition of documents expanded to include electronic or digital records, evidence to include any information given electronically. In conclusion, the interoperable criminal justice system and the introduction of new criminal laws represent significant milestones in our journey towards a more just, more easy, and a more equitable criminal justice system. By harnessing the power of technology and embracing progressive legal reforms, we are laying the foundation for a justice system that is efficient, transparent, and accessible to all. As we move forward, let us continue to work together to ensure that the promise of justice is fulfilled for every individual regardless of their circumstances.
Solicitor General of India, Shri Tushar Mehta, in his address said,
Every revolution needs a particular time where several things comes together. We have the will of the people to make this change which was ready to happen since 70 plus years. It is that change which the parliament brought and shifted the regime from punishment of those who are ruled to the justice of those who are citizens of India, who have given to themselves the Constitution of India. Friends, I would wish to highlight 2 or 3 very important changes in the regime, in the legislation, and in the way India thinks in the present era. I would like to highlight them. First, now we are in the digital era under the very able leadership of the Honorable Chief Justice of India, the judiciary, the judicial infrastructure, and even lawyers are shifting to the digitization and digital mode of dispensation of justice. For the first time, now the digital testimony of a witness is accepted to be a valid testimony. So now there is no necessity of people traveling all along from various parts of the country or the state to depose. This is a revolutionary change which was waiting to happen. Now electronic mode is permissible in all criminal proceedings. Second, the problem which this country was facing was that those who were criminals or at least facing criminal allegations used to either flee the country or they used to go somewhere hiding, and the courts were helpless because there was no provision and they were declared absconders. For the first time now, the Indian law provides that after a person who evades the process of law and is declared by the court to be an absconder, the court can proceed against him and even pass a sentence of conviction in his absence. People were facing one more difficulty, and this is where the role of the parliament comes. One of the main problem a common man was facing was a crime is committed either with me, or I have been witnessing a crime, or I came to know about a crime and I want to get it registered. When I go to a police station would say, this is not within my jurisdiction, I will not register an FIR. And under the old law, that was permissible defense for the police. For the first time, by a statutory mechanism, there is a provision of a mandatory requirement of what is called zero FIR. Even if I go to a nearest police station having no jurisdiction, it is their responsibility to register a zero FIR and transfer it to police station having the jurisdiction. Now, a common man of this country will not be told by any police station that we have no jurisdiction. They will have to register the FIR.
Attorney General of India, Shri R. Venkatramani, in his address said,
Every emergence of a social change in economical, social, political, and technological may trigger changes in human behavior. The right and wrong of behaviors can become crimes or undesirable. We are witnesses to this phenomena. Many legislations attempt to deal with behavioral changes, bringing in regulatory and penalty elements. These could be from environmental wrongs to cryptocurrencies or economic crimes or even anti-social peace crimes, besides other worrisome social behaviors. Debates on enhancing the justice content of a criminal justice system may have to move towards an integrated approach. Virtually, at a different level, every country is called upon to assess and take stock of its criminal justice system. The criminal justice system is not merely the penal laws the investigators, the prosecutors, the courts, the prisons, all in isolation, but in their interrelationships, as also the perceptions and attitudes of the peoples in the community towards crime is a very important element of administration of criminal justice. Current studies in neurosciences are ambitiously entering old debates on why people commit crimes, or for that matter, why and how we respond to external stimuli in certain ways. This could help us in understanding police behavior or the perspectives of judges on what to do with what deviant behavior. The huge literature in this field call for a closer look at many of our theories of crime and punishment. Deterrence, retribution, or consequentialism in the field of punishment are all open to new challenges from worldwide experiences. A paradigm shift, as we talk about in the fields of science and sociology, may have to happen in the field of criminal justice administration. The new penal code is not a penal code, but a Nyaya Sanhita. The elimination of many deviant behavior from list of crimes means movement towards decriminalization. I understand the use of the word Nyaya signifies social justice, that is, balancing justice between peace and deviant behavior, or social defense against deviance. In a sense, we are not in the days of mere condemnation on any preconceived notions of crimes. We have moved away from Beccaria or Jeremy Bentham, whose thoughts influenced Macaulay. Social peace, I understand, is Nyaya for everyone. Since we do not have the ultimate keys for understanding deviant behavior or belligerent attitudes, and which may impact social peace, we still need to deal with all shades of human conduct. The selective violations of laws, behaviors by people for many a reason will always be a matter of concern and responses. I understand the Nyaya Sanhita is an attempt towards doing that. However, fairness in process and substance will remain largely non-negotiable. The very thought of Nyaya, the underlying idea of the new code, suggests that we are closing our eyes to colonial or other ways of thinking. But we need to further strengthen this idea and probably segregate different deviant behaviors and treat them differently within the broad limits of fairness. Similarly, the new procedural code is not procedural, but protection. It talks about suraksha. Suraksha means protection and not mere procedure. This is in tune with moving away from a code which was an exclusive domain of investigation, prosecution, etc. All procedures must avoid coercions, compulsions, discomfort, and ensure self-protection. The use of the word suraksha is not merely symbolic, but the provisions are slated towards fairness. We need again to keep in mind the Nyaya element and the social peace element while looking at the suraksha element. The Sakshaya Adhiniyam has few features which seem to eliminate the needless clutter of evidentiary procedures. The law of evidence must be facilitating and not a house of choices of principles for the unethical. The legal fraternity for long has used the evidence law without ethical considerations. Some of the salient principles of Indian logic system or Nyaya Sastras have also not been invoked or used in the evidence law. I think we can have an appendix of such principles to guide the working of our system. We also need to have working guidelines for the investigation agencies as part of this law. Perhaps the world of police laws and codes of yesterday's need to be overhauled while retaining some time-tested features. Humanizing the police system can happen with these collaborations. Just as technology has fundamentally changed our lives and transactions, its utility in expedition and avoidance of wasteful procedures has been excellently captured in the Suraksha Adhiniyam and the Sakshaya Adhiniyam. As I said, more experiments in the world of understanding deviant behaviors are called for. I find that 3 new legislative instruments are significant steps. It is true, some aspects can be questioned as remnants of the old code, but what is important is a room for transitions. The Indian Penal Code was static in one sense. The very thought of becoming dynamic and moving with the times is important. The 3 instruments are promising in this way. I do not propose to scan them. However, I carry a fond thought that when laws are seen as instruments and not as mere power, we would have moved away from a power-hungry system or a system blind to human dignity, or also negotiated social peace. That some people or some behaviors will always be questionable and may not tally with morality or social peace will always be addressed with due responses and considerations. Maybe we need to set up a National Institute for Criminal Justice Administration to connect the threads of the new triumvirate of the laws.
The inaugural address was delivered by the Chief Justice of India, Dr. D.Y. Chandrachud.
The Bharatiya Nyaya Samhita, the Bharatiya Nagrik Suraksha Samhita, and the Bharatiya Saksha Adhiniyam. With the enactment of these three parliamentary legislations, India is set for a significant overhaul of its criminal justice system. These laws, in a sense, are a watershed moment for our society because no law affects the day-to-day conduct of our society like the criminal law. Criminal law directs the moral arc of a nation and has the ability of depriving people of their cherished liberties as well. The underlying justification for the substantive provisions is the age-old harm principle, which is best summarized in the saying, "Your right to swing your arm ends just where the other man's nose begins." Procedural law, which governs crimes from the state of setting the criminal process in motion to the conviction for the commission of the offense, ensures that no person is charged and subsequently convicted for offenses without the due process of law. The one thing which was the striking aspect of our triad of criminal laws was their age, 1860, 1872, and even 1973. And I think the enactment of these laws by Parliament is a clear indicator that India is changing, India is on the move, and that India needs new legal instruments to deal with current challenges which we envisage for the future of our society. The traditional harm principle found resonance with the understanding that crime is immoral. The father of criminology, Rafael Garofalo, defined crime as an immoral and harmful act that is regarded as criminal by public opinion because it is an injury to so much of the moral sense as is possessed by a community, a measure which is indispensable to the adaptation of the individual to society. The ideals underpinning the combination of harm and immorality are premised on the perception that deprivation of liberty leads to repentance and to moral salvation. There were two problems with this harm-linked approach to criminal jurisprudence. The first was that it is not a victim-oriented approach. The impact of the harm on the victim is not considered. Victims of crime often feel like their agency over their own decisions is lost by the commission of a crime. Our laws have therefore to aim to give victims a sense of agency and control in the criminal process, as well as a sense of justice. The second problem with the juristic foundations of our earlier laws was in regard to the harm and morality approach, and that it advances a perpetrator perspective to crime, which views crime as an individual failing. It does not address systemic causes which push people to commit crimes. Our laws needed to address these concerns and obviate age-old issues like delays in the examination of witnesses, delays in the conclusion of trials, the overcrowding of prisons, and the issue of under-trial prisoners. The 248th report of the Standing Committee of the Rajya Sabha on the Bharatiya Saksha Samhita of 10th November 2023 noted that the Indian criminal justice system has struggled to keep pace with the profound technological changes, our socio-economic milieu, and that these socio-economic changes have radically reimagined the way in which crimes manifest in society. The growing scope of technology and the new age crime which uses the digital landscape to create networks of collaborative units to commit crimes cannot be pinned to an investigative situs. Today's crime has no investigative situs, no physical situs. This has presented challenges in the investigation of crime, admission of evidence, and prosecution, as well as justice delivery. The newly enacted criminal laws have transitioned India's legal framework on criminal justice into a new age. Much needed improvements have been introduced to protect victim interests and carry out the investigation and prosecution of offenses efficiently. The BNSS encompasses a holistic approach to deal with crimes in the digital age. It prescribes audiovisual recording of search and seizures. The judicial scrutiny would safeguard the rights of citizens against procedural impropriety during search and seizures. Similarly, the presence of a forensic expert at the scene of the crime, which enhance the efficiency of the investigating team and allow for crimes to be decoded with the aid of the latest advancements in forensic technology. While we make strides in this direction, we must now confront the challenges of fulfilling the aims of the new criminal legislation. Detailed rules need to be formulated on the type of devices to be used for recording, incorporating the principles of natural justice, and lay down the consequences of not carrying out such recordings. We have strategically and persistently worked towards creating technologically equipped court systems, which can facilitate a citizen-centric and efficient mechanism from the filing of a case to its disposal. Section 532 of the BNSS allows for all trials, inquiries, and proceedings under the code to be conducted electronically in Section 532. As laudable as this addition is, we must continuously introspect and protect the privacy of the accused as well as the victim when dealing with digitization of proceedings and creating digital evidence. In the digital age, the data and sensitive information of a person has gained paramount importance. This data can allow us to gain unparalleled efficiency and ease. However, the power which comes with personal data puts a corresponding duty to make systems which are immune to penetration and leakage of data. In the courts, we confront the challenges of data leak every single day. The safety of a person, the stigma attached to an accused, the threat perception of a witness will be compromised if the privacy of the stakeholders is not protected by us. We must inspire public confidence in securing the privacy of our citizens to gain an overall efficiency and trust in the criminal justice system. Technology holds the key to a futuristic court system. It eases the court procedures for the litigants, court staff, and the judges. In particular, clauses 3 and 4 of Section 532 of BNSS allow for the examination of witnesses and evidence through the electronic mode. The access ushered in by this provision will impact the access of witnesses to the courts and reduce delays in trials on account of the absence of witnesses. Finally, I'd like to stress on the use of artificial intelligence. AI will enable us to track progress in criminal trials. We must deploy AI for the purpose of noticing aberrations in the process. When a trial is delayed, when witness testimony is delayed, AI will be able to flag for us red marks on why these delays are taking place, providing decision makers for supervisory control at all levels of the criminal justice administration, creating templates for simple orders and simple pleadings and simple filings. So technology today is replete with a world of opportunity for us. So it is not enough for us to only notice the radically new provisions of these 3 new legislations. A conference like this is important for us to educate ourselves about the changes which Parliament has brought about. But equally, we must focus on ourselves, because these new laws will be successful if we who are in charge of implementing these laws adapt to them not only in terms of our institutional process, but in terms of our mindset as well. As a very distinguished judge has said, the law is the witness and external deposit of our moral life. Its history is the history of the moral development of our civilization. And therefore, I hope that with this conference, all of you and all of us will be alive to both the challenges, the opportunities, and the duties which are cast upon us as important stakeholders in the implementation of law. Thank you.
With this, we come to the end of radio report on the inaugural session of the Conference on India's Progressive Path in the Administration of Criminal Justice System held in New Delhi.